This is Marc Movsesian. I'm the co-director of the Center for Law and Religion at St. John's, and I'm joined once again by my friend and colleague, Professor Marc DeGirolami, the center's other co-director, for an episode of Legal Spirits, our podcast series on cases and issues in law and religion. You can find past episodes archived on our website, lawandreligionforum.org, and also on Apple iTunes. Well, the COVID-19 pandemic has scrambled a lot of priorities, including in religion clause jurisprudence. Just now, we're not talking so much about issues like LGBT rights versus religious liberty or public funding of religious schools, although I should say we're expecting an important decision from the court any day. Rather, the religious freedom issue of the moment is whether the government can force churches and other houses of worship to close, or at least to curtail worship services in response to the COVID-19 crisis. State and local ordinances now forbid so-called non-essential gatherings of more than a handful of people. Usually it's something like 10 people. There are such ordinances in 38 states. The large majority of these ordinances apply to religious services. In these states, religious services are considered non-essential. Now, there are several lawsuits across the country challenging the legality of these orders, either under the Free Exercise Clause of the First Amendment or under one of the various state versions of RFRA. At this writing, there are 8 lawsuits. There was a very famous one, got a lot of attention during Holy Week in Kentucky, U.S. District Judge Walker's opinion holding that the city of Louisville could not close down drive-through church services got a lot of attention. Judge Walker made the point, if beer is essential, so is Easter. There's a Mississippi case in which the U.S. Department of Justice filed a statement of interest. In that case, a city in Mississippi had fined people who had attended a parking lot church service. The city later backed down about this. There are other cases in Kansas and New Mexico. Now, we should stress that most religious congregations across the country are following these new rules and are closing down for the duration. Here in New York, for example, the Catholic Archdiocese of New York has suspended masses, although churches remain open for private prayer. The Catholic Diocese of Brooklyn, where St. John's is located, has closed churches entirely. Many churches have gone to streaming online services. That's what my own church, the Armenian Orthodox Archdiocese, has done. And I have to say, Marc, we seem to be getting some better attendance now that we've gone to streaming than when we're actually live in place.
Well, that might be. I attended Easter service by waking up at, very early in the morning and watching the Mass officiated by Pope Francis in Rome. And so I think people are learning to make do in this difficult period. And in some ways, I mean, obviously it's nicer to attend Mass, much nicer and very important to attend Mass in person. But that was the kind of experience that I don't think I would have ever have thought of doing. And so I did get to see something special, albeit very different.
Right. We can shop around now. I've actually done a little bit of that, shopping around the different parishes in my archdiocese, but I stick with my own most of the time. And as I say, we're doing pretty well. I think the attendance really has gone up since we've gone to streaming.
It might be the novelty.
Maybe the novelty, maybe. So now there are good prudential reasons for this reticence. Churches don't want to spread the virus, and we should note that many clergy here in New York and elsewhere have gotten sick. And not a few have died, sadly, as a result of COVID. That's one reason. And secondly, I think churches may not want to give ammunition to people who are disposed to curtail religious liberty. And this is a point which an official with the Archdiocese of New York recently made. So there are good reasons for doing this. And most churches are following the orders and not opening. But some, and I have to say, Marc, it seems mostly evangelical Protestant churches are testing things. And in this podcast, we're going to analyze the legal situation. Are these challenges likely to succeed or fail? Now, we're going to speak generally. These cases will turn on the specific language of the ordinances at issue, and we can't get into details here. And we're also going to focus on the Free Exercise Clause of the First Amendment rather than state RFRAs, even though state RFRAs are obviously implicated. We just can't get into all the details of these state RFRAs. The bottom line, Marc, I think is it's not clear how these cases are going to come out. I would have thought that most courts would uphold these ordinances, either under the Smith rule that we're going to talk about or under the compelling interest test. But there seems to be a strong motivation to challenge these rulings. And the DOJ's recent intervention in Mississippi suggests the Trump administration may support plaintiffs. And of course, there are a lot of new judges. So who knows?
Yeah, no, I think you're right about that. I would have said certainly in the early period of the crisis, or the very early, you could say that even now this is the early period of the crisis. But in the earliest days of the crisis, I would think that any challenges would be likely to be rejected. But as time goes on, as we'll talk about, and as things slowly begin to reopen and things become sort of more complicated, the sort of time horizon becomes more extended, things become more complicated legally too, and less certain.
Yeah, and very good. We'll talk about this. We're also going to talk about some sociological issues about what these cases suggest about American religion at this time. I mean, for example, why do the protests seem limited mostly to Protestant evangelical churches as opposed to Catholic churches and other religious houses of worship? And we'll also talk about that point that the archdiocese official made, which is it a good idea for churches to be pushing the envelope right now? Let's pose a hypothetical case, which is a composite of some of these cases around the country. Let's say that a local government prohibits gatherings larger than 10 people except for quote unquote essential services, such as grocery stores, pharmacies, home repair and DIY stores, liquor stores. Those are typically included, Mark, in the category of essential services.
Yeah, you and I may have a something of a disagreement about whether they fall into the most necessary or the somewhat less than fully necessary category.
Yeah, maybe. Okay. But but essential purposes do not include, under our hypothetical ordinance, do not include sporting events, musical concerts, schools, museums, and religious services. The government justifies its ban by public health, or in the interests of public health. So, Mark, how would we analyze this case? Would a religious accommodation be required in a case like this?
All right. Well, so here we start out, at least for constitutional purposes, with cases. One case in particular that's going to be familiar to our listeners. We've talked about it many times. We've talked about challenges to it many times, and that's the famous Smith case from 1990, where the court said that the free exercise clause doesn't require an accommodation where a law is neutral and generally applicable. So, yes, these terms are contested terms, but neutral generally means that the law isn't motivated by a hostility to religion or isn't targeting religion as such. And generally applicable means that analogous non religious conduct is covered, or that the coverage of the rule is such that it looks like it's fair, that it's not being sort of applied only in this case or for some sort of favored issues, but not for others. So the basic idea is you can't target, and you want to see a sort of as much of a blanket coverage with respect to the rule as it is reasonable to expect.
Well, so how about our hypothetical ban on gatherings here, right? I mean, let's take the first part of this.
Clearly, on the issue of neutrality, it doesn't seem like these regulations are meant to target religion as such. I mean, if anything, religion is simply one of a cluster of kinds of human activity that is excluded, but it doesn't seem to me that religion is singled out for specially bad treatment. So that one seems fairly easy, at least with respect to the regulations I've seen, right, Mark?
I agree. There's absolutely no indication that this is somehow these orders are somehow motivated by hostility against religion. Okay, but how about generally applicable? I think, Mark, that might be a little more difficult.
Yeah, I think that's right. So it depends. It depends on how we see the coverage of these regulations and how we see the exceptions that are being made to them. So at the moment where the regulations were truly across the board, or the coverage was across the board, well, then it's easier to say that they're generally applicable. But as you said in our hypothetical, we are excluding sporting events, musical concerts, and school gatherings. So that's, you could say, well, that's non-religious conduct that is in the non-essential category. So at least to that extent, again, religion isn't being singled out, but grocery stores, pharmacies, liquor stores, and by the way, I should add now things like golf courses, marinas, right? I mean, those are increasingly being exempted. So you might say, well, if those are being exempted from the regulation, well, in what way exactly are they different from religious gatherings? Mark, what do you think about that?
Yeah, Mark, I think actually it's a difficult question. I mean, what we're essentially saying is what is essential? And, could a state say that, well, religious services are not essential in the same way as grocery stores are, as pharmacies are? After all, most of these ordinances, and including our hypothetical one, they also closed museums, they closed schools, they closed a lot of things that we would think of as essential, but not in the same way as a grocery store is. Now, as we start getting into things like golf courses and marinas, well, then it does start to seem like this is not a generally applicable statute. There are a lot of things that are being excluded, and it's not sure why religion wouldn't be on that list.
Now, look, it is possible that the state could come up with neutral or a sort of non-religion based explanations. Golf courses and marinas are outside, for example, or perhaps it's more possible in the case of liquor stores and grocery stores to limit the numbers of people that are going in and out, whereas in churches it wouldn't be. But I'm not sure about that distinction, actually. I think it probably would be possible. And I think even in the example that you just gave of some churches staying open for private prayer, where they're staying open for private prayer because they are just in that way limiting the number of people that are congregating at the same time within the church. So there are all of these kinds of issues, it seems to me, that are going to come up. Golf courses and marinas, that's outside, so that's a little bit different, maybe.
Right, I agree. So, look, we're essentially asking here, are the religious services analogous to those things that are being kept open? And if so, it's hard to say this is a kind of generally applicable thing, because why would they be excluding religion? Now, my intuition going into this, Mark, is that most courts would have just said okay to these ordinances. And I'm just speaking here as a legal realist. I mean, whatever doctrinal requirements, I would have thought most judges would be unlikely to second guess governments in the middle of a pandemic. I would have guessed they were unlikely to say that this was not generally applicable. And there is a case, we've talked about this case in an earlier podcast involving vaccinations. It's a case called Jacobson from 1905, in which the Supreme Court gave broad power to a state, I think it's the state of Massachusetts, to order a mandatory vaccination campaign. And the court said, the state's interest in promoting public health outweighed whatever liberty interest someone had in not being vaccinated. And that's not a free exercise case, and it was a different test. I understand all of that. But there is some flavor of Jacobson in this case too. This is a pandemic, and the government needs a lot of leeway in deciding what to do.
Yeah, and we should add too that there are a number of state court decisions that have rejected religious freedom challenges, whether under the state constitutions of the states involved, to mandatory vaccinations for children who attend school, that have rejected challenges to state mandates related to what were considered to be at the time truly necessary public health grounds. But obviously, though, as you know, in light of the summary of the case of Judge Walker's. By the way, we should add Judge Walker is somebody who was recently nominated by President Trump to the D.C. Circuit. So that is
Yeah.
not just any old district court judge. It's a judge with a certain amount of prominence, at least recently. And some judges, like Judge Walker, are willing now to second guess this kind of determination. Right? We talked about Judge Walker. That basically he says, look, this is excluding religious services, as it happened, during Holy Week, while allowing liquor stores to be open is a kind of targeting of religion for disfavored treatment. And Jacobson was really a different kind of situation. So it's difficult to know.
So you never know. Now, okay, so assuming that a court would determine that our ordinance is not neutral or generally applicable, then under Smith, we would move to, I think, now, Mark, you and I maybe differ a little bit. I think we would move to a compelling interest analysis under Smith.
Well, it's not that we differ, Mark. It's that to me, it's unclear. So I think after some of the recent cases that we've seen, cases like Masterpiece, sort of Justice Kennedy involved cases, It isn't absolutely crystal clear whether a finding of non-neutrality and or non-general applicability moves you into a compelling interest framework or knocks the law dead right then and there. But let's assume, for the sake of argument, that we do move to a compelling interest analysis, as you suggest.
So
Um,
what would happen then?
all right. Well, so then again, for listeners, right, this is this familiar burden shifting approach, moving from the claimant having to allege a substantial burden, and then the burden of proof shifting to the state to show that it has a compelling interest in its regulation that is narrowly tailored to serve that interest, right? So that's the inquiry that we go to then.
Okay, so let's go through that. Now, I think in terms of substantial burden, I think it's not really a question. Obviously, if you're preventing people from gathering and worship, that's a substantial burden on religious exercise. I don't think the compelling interest is particularly controversial either. This is a pandemic, it's a public health emergency. So, the state can certainly say we have a compelling interest in preserving human life and in flattening the curve and tamping down the pandemic. So, really, we're now going to be talking about whether it's a compelling interest with respect to these particular churches and whether there is a least restrictive means of attaining that interest.
I think that's true. Although before we even get there, I do think it's on the compelling interest side of things. It is often the case that a court won't just say, "Oh well, public health. That's the obvious compelling interest. Full stop. Let's move to narrow tailoring." Sometimes, and it seems to me this may be the case here. Sometimes courts will question whether an interest is truly compelling by inquiring just exactly about how complete the regulation's coverage is. So, as an example, right, a regulation that has lots and lots of exceptions in it begins to weaken the state's claim that its objective is really as compelling as it says that it is. And a regulation with only secular exceptions, not the sort of situation we have here, but just suppose that we did, that only has secular exceptions, that has no religious exceptions, that will make a court suspicious. Not so much, again, that the state is targeting religion, but that again its justification for the interest that it is claiming isn't quite as compelling as it says that it is.
So once again, Marc, we're asking, well, how willing is a court going to be to second guess the government's determination that some things really are essential and must be kept open? Grocery stores and pharmacies and religious services are just not in that category. We're asking the same kind of question here.
Yeah, no, I think that's right. And it's one thing when the as I say, when the pandemic, when it was in its earliest days and the shutdown order was really fairly comprehensive with the exception of things like food and drink. Now that states, the individual states are talking with the individual governors are talking about gradually reopening things. Well, now the question becomes it becomes more the disparity of treatment becomes more acute, at least with respect to the kinds of issues that we're talking about. And so, for example, I was struck that the first thing that Governor Cuomo here in New York talked about opening here were marinas and golf courses. And I suppose, a certain class of person does think that those venues truly are essential. Right? He was even mentioned, I was talking with the other governors and boy, do we miss the marinas. I was like, really? Like I don't miss the marinas at all, right? I mean, that's the last thing that I would think of as essential, but I'm just probably not a very big boater, I guess, right?
Right. Well, but then there's a good question, right? Which is if marinas are essential, then how come churches are not essential? Mike McConnell, a professor at Stanford, a friend of ours, has an op-ed in the New York Times in which he says, if liquor stores are essential, then why isn't a church essential? And that's sort of a question. I
Right.
mean, a good question.
I think you're right. So look, at the very least, it's one thing to say food stores have to be open and everybody else has to be closed. But it's another thing to say golf courses, marinas, and liquor stores have to be open, or can be open, but churches cannot be open.
Now, to be fair, again, we're not opening museums, we're not opening concerts, we're not opening schools, even, right? So, but I agree with you. And so, for the listeners, look, I guess DeGirolami and I are saying, well, we just don't know how this will come out, but we know what the test will be. I'll say again, Marc, and I think you agree with me on this. Just going into this, I would have been surprised to find many courts being willing to overturn these ordinances in the pandemic, but we have some judges who are doing it, and the arguments are not outlandish, as you and I have been discussing.
They're not outlandish, and I agree with what you say, Mark. I'm in agreement, but I do think that look, and these are time sensitive things, right? So you say that there's an emergency, and people will say, okay, they'll snap to and recognize it for what it is, and it is an emergency, and continues to be an emergency. But if you don't treat it like an emergency with respect to the exceptions that you make across the board, then people are going to start to wonder, well, what is this then? Is it really the
Yeah,
emergency that you were claiming that it was? Or is the emergent quality of it kind of diminishing such that some things that aren't quite so absolutely necessary are now being, and then how do we decide which things are necessary? So I think that's all
that's
coming.
yeah, no, that's a really nice point, Mark. And I have to say, as I've thought about this issue more, I've become somewhat more sympathetic to the argument that you can't open liquor stores and Home Depot and marinas and golf courses and then not allow a church to have an open air service, which is what was happening, by the way, in Kentucky.
Right.
Okay, let's talk a little bit. Let's talk a little bit now about sort of the cultural moment here. And one thing, Mark, that struck me is these cases seem to be mostly from evangelical Protestant churches. They seem to be the churches that are challenging these rulings. I know that the Catholic Archdiocese of New York, their spokesperson said, maybe it was even Cardinal Dolan, said, "Look, we have no interest in civil disobedience on this question. We're not going to insist on staying open for liturgical services." And I wonder why is that? Because the irony is that for evangelical Protestants, a church service is a gathering of people to worship God, but you could do that online pretty easily. You could listen to a sermon online. For Catholic churches, for Orthodox churches like mine, there's a much stronger argument that you need to be present because you need to receive the sacrament, you need to receive communion. And yet, it's not the Catholic and Orthodox that are complaining about this, and it's not even the mainline Protestants, it's evangelical Protestants mostly.
Yeah, so this is interesting. It's hard to know just why there may be if there's not a theological explanation, perhaps there's a political theological explanation, which is I mean I think it is true at least historically that there's a kind of streak of independence and anti-government spirit in some of the political culture of evangelicals and
Separationism.
separationism, which is, dare I say it, perhaps somewhat less pronounced in at least some of the Catholic circles that I travel in and know about. But I do think, at least as a historical matter, this kind of suspicion, let's say, suspicion of the government and of government regulation is perhaps more acute or more deeply felt in the kind of political theological circles of evangelicalism than it is in Catholicism. So maybe that's just a speculation. I mean, I have no way of knowing, but that might be part of the explanation.
No, I think it's a nice point, Mark. I think there is more of an oppositional culture in the evangelical Protestant community, oppositional to the government, than there may be in some other communities. But it does strike me, it is something that asks for an explanation why the liturgical churches, which really do need to be in person for worship services, are not protesting these closures, and others which are not as reliant on liturgy and sacrament are the ones.
Now, I will say this to be fair, we're as we've been saying all along, we're in the earliest period of this crisis, and uh, whether we see similar forbearance on the part of different sorts of churches as time goes on, and more sorts of exceptions are made, and they continue to be commanded to be closed. That's a different question, I think.
Yeah, that could be. Another issue, Mark, I'd like to talk about is just this comment. I was really struck by it on the Catholic Archdiocese of New York website. It's Ed Meckman, who is one of their officials, said, this really is not the time for conservative Christians to be trying to push the envelope when it comes to resisting the government. That actually struck me as correct, Mark. I think it probably isn't the right time, given the fact that, as it is, there's a substantial amount of suspicion among some aspects of the wider culture, our media culture, for example, about religious liberty. They see all of this as extremism. And I have to say, insisting on being open in a pandemic only feeds that image of religious liberty as basically an extreme position. What do you think, Mark?
That you might be right about that. In fact, I think it's probably true that opponents of religious exemptions more broadly. I remember this kind of that this is a claim actually that was made. I remember in the Hobby Lobby litigation, and I think was even referenced in Justice Ginsburg's dissent. She may have talked about vaccination. So I think opponents of religious exemptions. I'm not saying Justice Ginsburg is an opponent of religious exemptions, but I do think that there are people that do oppose religious exemptions and they have for a long time tried to make analogies in all sorts of different contexts involving health understood in a very broad health or wellness understood in a kind of broad-based way um, to the vaccine situation. And so the
Yeah.
coronavirus is just the sort of example that it seems to me would be rhetorically appealing to them is to say, look, I told you so, right? These people, they're going to stop at nothing. They don't care about human death so long as they get the religious exemption. Now, on the other hand, if the crisis begins to normalize somewhat, right? I mean, it sounds like difficult to know at this point, but if it starts to normalize or become at least somewhat more normal than it has been, then the sense of acuteness is going to start to wear off. And when that happens, it's going to be a matter of, it seems to me, timing and strategy for litigators as to when to bring this kind of challenge and before which court and that kind of thing. So the calculus is going to change, I think, a little bit with time.
Yes, I think that makes sense too, Mark. Okay, listeners, well, thank you very much. We're going to keep an eye on this. We're also keeping an eye on the Espinoza opinion, which should be coming down pretty shortly from the Supreme Court about the funding for religious schools in Montana, and many other cases and issues in law and religion. So please stay tuned. Meanwhile, until then, this has been Marc Movsesian and Marc DeGirolami from the Center for Law and Religion at St. John's with another episode of Legal Spirits. You can find past episodes archived on Apple iTunes or also at our website, Law and Religion Forum, that's one word, .org. See you next time.